Thank you very much, gentlemen. We are moving now to a side issue, but one that I think you'll find very interesting that took place in the state of Minnesota. The chairman of the NBA Historical Committee is Frank Grace Jr., and he's going to come up and give us a quick overview of the case in Minnesota that could have had the same impact as Baker versus Carr, but did it? Come tell us.
Baker versus Carr may have occurred ultimately anyway, but because of the case from Governor v. Donovan, it occurred when it did. This is a case out of the Federal District Court of Minnesota. The reason this is important is that, as you'll see, it was the genesis of Baker versus Carr. And the root causes and the civic zeal of those who are involved in many respects just mirrored those of the situation in Kidd versus McCandless. But as I said, with some structural and procedural changes, it became the genesis for Baker versus Carr and the decision in that case. Minnesota was not unlike the state of Tennessee in that in the middle 50s, in that 20th century, people had begun to move and had been moving steadily from the rural areas to suburban and urban areas, and the population became concentrated in those areas. Reapportionment provisions of the Minnesota Constitution were based upon those of the state of Tennessee. It had not been reapportioned since 1913, 12 years after the state of Tennessee quit doing that sort of stuff. By 1959, the districts in Minnesota were wildly disproportionate, but the legislature obviously was not doing anything. In 1945, there'd been a challenge similar to Kidd versus McCandless. It had went in the trial court, reversed in the Minnesota Supreme Court for much the same reason that the Supreme Court of the U.S. would give in Coldwell versus Green the next year in 46, the political theory thicket argument. There were subsequent legislative efforts in 51, 53, 55 by the same legislator to reapportion the legislature. They all were met with derision and sarcasm, and the equivalent of Jim Cummings in the Minnesota legislature simply vowed that there would be no reapportionment while he was in the legislature. The protagonist in the McGraw-Donovan case, McGraw was a CPA, not a lawyer, but he came from a very civic-minded family. He got to know the legislature through some consulting projects and serving on some state boards. And kind of like Mack, he was shocked that the legislature was just ignoring the state constitution and not reapportion itself. He liked to bug his neighbor, Frank Farrell, who was a lawyer, that somehow the law could not, the legal system could not enforce what plainly was written in its constitution. Farrell agreed, but he was aware of the case law and the situation that confronted any change. Farrell decided to run for the legislature in 1956, and in looking at these issues of reapportionment, while McGraw was talking to him, he came across a case out of the Territorial District Court in Hawaii, Dyer versus Abe. The case didn't have much precedential value, but the court did hold that the failure to reapportion denied the citizens of Hawaii the equal protection law. Farrell decided to make that the cornerstone of his campaign for the legislature, and he lost in 1956, in November. But the next month, he and McGraw decided to try the federal courts. Kidd versus McCandless was reaching its death knell in December of 1956. Tommy Osborne had taken it into the federal court system, had applied for cert to the U.S. Supreme Court, and was denied in February of 56. Like many of the lawyers in the Kidd versus McCandless case, and later in the Baker versus Carr, McGraw and Farrell were young. They were 35 and 36, respectively. They were not members of the establishment at that point. They became members. McGraw became employed by IDS, a huge brokerage and investment firm. Farrell was a railroad lawyer, but ultimately put together and became general counsel for Burlington and Northern Railroad. Both were Republicans, and a strange amalgam of professional and civic interest. Both men were affiliated with the ACLU. Farrell was a Minnesota state chairman of the ACLU at one time. Mr. Farrell's son tells me in a conversation that their views diverged over time. Farrell had a practical approach, like many of us, to preparing his lawsuit and getting it ready for trial. He tried to get a bunch of other lawyers to help him. Ultimately got 6 lawyers from major firms in Minneapolis and the Twin Cities to help him. One of them made a vital contribution. He had a brother-in-law who just got a PhD from the University of Minnesota, and his thesis, he had done the statistical work and compilation to show the disproportionate representation of each house in each Senate district in the state of Minnesota. That thesis, was exhibited to the ultimate complaint, and the young professor testified at the ultimate hearing. McGraw, ever helpful, went back and found his political science professor at the University of Minnesota, who had written a treatise on the impact of malapportionment on the legislative process across the country and the effect of the failure to reapportion on the political system. That work was later exhibited to a trial brief and became part of the proof in the McGraw case, of course, and later on in Baker versus Carr. The 3 plaintiffs in McGraw, in addition to McGraw, were drawn from malapportioned legislative districts. The defendants were more narrowly drawn than they were in Baker versus Carr, and this is Kidd versus McCandless, and this is a key distinction. They wanted to avoid the political rancor and all of the what we'd say today, the fallout from suing the governor and all the legislators. Mack, when the case was first brought, didn't do that, but in a cross-action he mentioned Hobart Atkins, who was the commissioner of elections in Knox County and a Republican, decided that he would file a cross-action. They had their own agenda and goals in this process, and they named all of the legislature and the governor. But the pleadings in McGraw were much more narrow. I cite Gene Graham in my materials, and according to Gene, he wrote a book on one man versus one vote. When Farrell filed his lawsuit in February of '57, just 2 months after Kidd versus McCandless, Farrell was aware of Kidd versus McCandless. He'd read the case. He may not have known it, though, but he would have been pleased to know that in his jurisdictional statement, Tommy Osborne, trying to get before the U.S. Supreme Court, cited the Dyer versus Abbey case that Farrell had come across and had given him the impetus and the idea that here perhaps is the course of argument, the equal protection of the 14th Amendment. The remedy sought by Farrell was declaratory. The Declaration of the 1913 Act was no longer valid, and he sought injunctive relief that the defendant electors, commissioners, not be able to conduct elections under that statute. The legal predicate was Section 1983 of the 1871 Civil Rights Act and the 14th Amendment. In March of '58, the district court overruled the motion to dismiss, went to a 3-judge panel as constitutional issues must, and after a day-long hearing in May of '58, when only 4 witnesses were called, the hearing in May '58, and 2 months later, in July of '58, the 3-judge panel issued its opinion, very concise. This court has jurisdiction of this action because the federal constitutional issue asserted. That was the ballgame. They needed to get into federal court and get somebody to listen to this sort of claim. The court, though, was not ready to give up on the fading presumption that the legislature would do what's right and what the Constitution required it to do. It retained jurisdiction until 60 days after the new legislature came in, it would be 6 months later, and gave the parties 60 days after adjournment to come back to the court for any relief they needed. Well, lo and behold, the Minnesota legislature called a special session or extra session in April of '59 and reapportioned somewhat. That was a disappointment to lawyers in Tennessee, including Tommy Osborne and others who've been following McGovern, because they saw that as a real entry point for them. Because of the reapportionment, although it didn't meet the standards that the plaintiffs wanted there, they thought they had just about gotten all they could get that time around, didn't want to test their luck, and so they dismissed their case late in October of '59. But lawyers in Tennessee, including Walter Chandler in Memphis and others, had been corresponding with Farrell and talking with him and writing with him and following McGraw versus Donovan, and based a great deal of what they did on that case and what the three-judge panel had said and done. In the fall of '61, following the argument that you heard up here at the beginning of this session, Walter Chandler wrote to Frank Farrell and said to him, "You'll be interested to know that much of your work was the basis for the case that finally reached the Supreme Court. While you were not present in the Supreme Court, the results of your work were very evident there, and we hope that the case of McGraw versus Donovan will shine the genesis of a favorable decision by the highest court." It did.
All right, we're a little over our schedule. We're going to try to catch up here in the second part, but we do have a very important segment coming up, and then we'll have a break. We may shorten the break just a little to try to catch up. And before I invite John McLemore to come up, I'm going to, I guess, sort of set the stage a little bit for what he's going to tell you about in the district court regarding Baker versus Carr with a short clip from Harris Gilbert.
Well, it was one of those fortuitous events, things, you know, sometimes you get lucky. I was having lunch at that time at the Nashville Coal Mirror Club, which was kind of a political gathering spot. I had my father was with me, and I think my uncle, who was at that time chairman of the Nashville Electric Service Power Board, and about 6 or 8 of us were sitting there, and the mayor was having lunch with us. Or maybe we were having lunch with him, be more like it. Anyway, he started talking about he felt that it was blowing in the wind, that the Supreme Court of the United States had just within a vote ruled in favor of Mayor Bill Hartsfield in Atlanta regarding the Georgia unit system, which was a notorious method of keeping Atlanta out of any meaningful participation in the state legislative process. And he said, "I think it's time that I challenge it. I need to get in this lawsuit." Ben West, Mayor West, said, "I need to get in this lawsuit." So they laughed at me the last time I'm going to take it from in the legislature. I went up there, I told them what was happening. I told them it's time that they try to work something out. If we can do it without litigation, I would be happy, but it's time for us to do something. And do any of y'all know anything about Coal Grove versus Green? Mayor West said. Everybody looked around saying, "What's he talking about?" I said, "The hell up my hand." I said, "I do." And I didn't know what he was leading up to, but he said, "Well, tell me what you know." And I told him what I knew about Coal Grove. That was the case I was referring to that had been somewhat misapplied, but was considered a case that stood in the way of reapportionment suits. And I told him I'd studied it. And luckily, I had the professor that I'd studied under for 2 or 3 straight days was the law clerk for Justice Felix Frankfurter. And he was in the course I was taking was federal jurisdiction. And I knew the strong points and the weak points that we had based on Coal Grove. The strong point was that there were 4 judges in that case who ruled that the federal courts do have jurisdiction in these voting rights cases. Excuse me. And 3 said they don't, amongst them being the leader being Justice Felix Frankfurter. But the 4th judge, Judge Wiley Rutledge, held that although he voted that they had jurisdiction, it should not be used at that time because the election was only 2 or 3 weeks off and did not want to interfere with the congressional election based upon the claims being made. Mayor West said, "I think you know something about this." And I said, "Well, I don't know whether I know something about it, but you asked and I told you what I know." But 10 days later, he called Tom Osborne, my senior partner, and me, and said, "I want y'all come over and talk to me about this. I want to get in this case. I just want to get into it." Started talking. Well, we listened, which I I think at that time was one of my better attributes at that time. I'm not sure I do it anymore, but we listened, let him go on and on. And finally, I'm going to get in this case. I'm going to get the city council to back me, and I'm going to get the facts and figures for you. People keep saying this is so, this is so, this is so. I want the city planning commission, I believe it was the city county planning commission actually at that time, they will enable us to present a good case. So we got together with, I went out and spent several sessions with Mr. Hand, who was the head of it, Mr. Hawkins, who was the co-head, and a fellow named Joseph Haas, who was their statistician. And we put together plans that showed you could easily reapportion the state. This was no magic stuff. You could easily do it. Number two, there was a great correlation between the amount of taxes being collected and how they were distributed back to the counties and the voting strength. I mean, this wasn't theoretical politics. It wasn't something that one would look at a political science class and say, oh, gosh, this is what must be happening. This was fact. This was fact that those who were being overrepresented got the lion's share of the money from the gas tax, from the sales tax, which was starting to boom, even the liquor tax. 95% of the counties in Tennessee were dry, but they all shared in the liquor tax.
So you can see, younger lawyers, there is an advantage to going to the Colmere Club with your father sometime for lunch. I urge all of you to get out more and cross-pollinate with some of these older lawyers.